Hello everyone. Today I am going to give a brief note on expert opinion under Indian Evidence Act. Section 45 to Section 51 under Chapter 2 of the Indian Evidence Act provide relevancy of opinion of third person, which is commonly called in our day-to-day practice as expert's opinion. These provisions are exceptional in nature to the general rule that evidence is to be given of the facts only which are within the knowledge of a witness. The exception is based on the principle that court cannot form opinion on the matters which are technically complicated and professionally sophisticated without assistance of the person who have acquired special knowledge and skill on those matters. Conditions for admitting an expert opinion are as follows. That is, that the dispute cannot be resolved without expert opinion, that the witness expressing the opinion is really an expert. Now, let us see who is an expert. The Indian Evidence Act does not enumerate any qualification or standard for being categorized as an expert under Section 45 of the Evidence Act. The term used by the provision is person specially skilled. In order to have a broader understanding of the term, it would be preferable to illustrate the same through precedents. The Supreme Court, in the case of State of Himachal Pradesh versus Jailal and others, explained who is an expert in the following words. An expert witness is one who has made the subject upon which he speaks a matter of particular study, practice, or observation and must have a special knowledge of the subject. In order to bring the evidence of witness as that of an expert, it has to be shown that he has made a special study of the subject or acquired a special experience therein, or, in other words, that he is skilled and has adequate knowledge of the subject. Expert is defined under Section 45 of the Indian Evidence Act 1872. The court needs an expert to form an opinion upon foreign law, science and art, identity of handwriting, identity of finger impression, electronic evidence. Only in the expertise in the above said fields, a person's opinion is considered to be an expert opinion. If a field not mentioned above requires an opinion, it is not considered as an expert opinion. There have been such cases like the disposition or temper of animals, color, weight or scale of similar facts, age of person, if a man or woman were intimate, if a person was intoxicated or not. If an expert is giving an opinion, it is considered as a relevant fact for the case. An expert has devoted his time in learning a special branch of expertise and thus is specially skilled in the subject. It can include superior knowledge and practical experience. The court of law, before admitting any of the opinion made by an expert, needs to ensure that the person is an expert under the law. If it is found that the person is not an expert, his opinion is discarded by the court. For checking that the witness is an expert, he must be examined and cross-examined. A person becomes an expert by practice, observation, or experience. In the case of Ramesh Chandra Agarwal versus Regency Hospital Limited and others, the court stated that the first and the foremost requirement for expert evidence to be admissible is that it is necessary to hear the expert evidence. The test is that the matter is outside the knowledge and experience of the layman. Now let us see what is the evidentiary value of expert opinion. A court is not bound by the evidence of the expert, which is to a larger extent advisory in nature. The court must derive its own conclusion upon considering the opinion of the experts, which may be adduced by both sides cautiously, and upon taking into consideration the authorities on the point on which he deposes. The value of expert opinion rest on the facts on which it is based and his competency for forming a reliable opinion. The evidentiary value of the opinion of expert depends on the facts upon which it is based and also the validity of the process by which the conclusion is reached. Where the experts give no real data in support of their opinion, the evidence, even though admissible, may be excluded from consideration as affording no assistance in arriving to the correct value. Evidence of experts, after all, is opinion evidence. The opinion is to be supported by reasons. The court has to evaluate the same like any other evidence. The reasons in support of the opinion, if convincing, make the opinion acceptable. It is for the court to judge whether the opinion has been correctly reached on the data available and for the reasons stated. Hence, from the judicial pronouncements, it can be inferred that expert evidence or opinion is not a cognate or conclusive evidence, and to make it a stronger evidence in a case, it has to be supported by reasons and relevant data. Now let us see what are the duties of expert. An expert witness is one who has made the subject upon which he speaks a matter of particular study, practice, or observation, and must have a special knowledge of the subject. In order to bring the evidence of a witness as that of an expert, it has to be shown that he has made a special study of the subject or acquired a special experience therein, or in other words, that he is skilled and has adequate knowledge of the subject. An expert is not a witness of fact. His evidence is really an advisory character. The duty of an expert witness is to furnish the judge with the necessary scientific criteria for testing the accuracy of the conclusion so as to enable the judge to form his independent judgment by the application of this criteria to the facts proved by the evidence of the case. The scientific opinion evidence, if intelligible, convincing, and tested, becomes a factor and often an important factor for consideration along with the other evidence of the case. The credibility of such a witness depends on the reasons stated in support of his conclusion and the data and materials furnished which forms the basis of his conclusion. Thank you.